Normally, our winter workshop is sort of the flagship program of Calcutta Research Group. We've been holding it, in different avatars and different forms for over 17 years now. And recently, that is, about 5 years back, we decided to do it together with the annual conference. Now, the purpose of the annual conference was, mainly so that our winter workshop participants could get different perspectives on the situation of refugees and migrants. Because, as you know, Calcutta Research Group is known for its the winter workshop for us was a time for rejuvenation. It was a wonderful time when all of us got together and really felt recharged. And we also felt that we are not alone. We are not the Don Quixotes of this world. Because whenever we talk of refugees and migrants, it seems like we're just talking amongst five people. We keep discussing the same things among five people. I don't know how much of it percolates to the wider audience. Because the picture that you get out of media, even from sensitive media, is very partial to what the truth that is seen by most of us who are working as scholar activists in the field. But having said that, I'm very happy that we could do this winter workshop in a hybrid mode this year, and we could have all of you with us today. Today's topic again is the perspective of protection of refugees and migrants in Southeast Asia. Now, one has to remember that apart from refugees and migrants being sort of the vulnerables in one perspective, and in another perspective, they are probably the most resilient people in the entire region. But the entire paradigm has now taken a different hue because of this pandemic that we are all, working with. As you can see, I was just wearing my gloves, my mask here and my gloves and everything, even sitting at home. So we have to deal with this reality as well. Um, and in this particular context, Southeast Asia is a very interesting region. Sometimes we scream that this region has really managed the pandemic. And in other times, we say, oh my God, there's so much violence as a result of this pandemic. So today, we have four people who are experts in the field. Although Sarah, I will claim for South Asia, since
Yes,
she's
that's
from
right.
Bangladesh, but Sarah is
Exactly.
quite an international personality. So she is a very welcome addition to this team of speakers. We will first start the discussion with Nayana Thanawathu, who's from obviously Thailand. She's from Asylum Access in Thailand, and she's been in this field of humanitarian work for many many years now, and her particular field is child protection. So we are looking forward to listening to you, Nana, and then the next speaker will be Malini. Malini is the director of DHRRA Malaysia, which is a Malaysian NGO, and they have also worked with UNHCR. And so we will get a perspective on Malaysia. And then, of course, we have Rizka, who is from Indonesia. She is a human rights activist in Indonesia. Her work with the freedom of religion and belief and some of her publications were about human rights violations in Indonesia, particular to the Ahmadiyya community. So we have three very prolific speakers, and we have again an extremely prolific discussant. And I don't really have to look at my bio notes to know who she is or tell you who she is. I think she is one of the directors of Kamal Hussein Foundation, and also she's an ace lawyer. We've heard about many of her cases. Sarah, if I'm not mistaken, you got notoriety, I think, with fighting for Taslima Nasreen. Isn't
That's
that
right.
right?
Yeah, I guess that's one way of putting it. Yeah.
Yes. And are you also involved with, I know legal aid, you involved with, what about I know Shalish? Are
Yeah,
you also,
I'm a member of the organization. I'm a partner at Dr. Kamal Hussein Associates, and I
yes, you're
work pro
the
bono
partner,
and stuff.
yes, of
Yeah.
Dr. Kamal Hussein Associates. And just an inner tidbit, since this is a very informal group. Sarah is also a very, she's a very well known sort of daughter of illustrious parents. And Kamal Hussein, and her mother also is extremely illustrious and famous. So, and I've been with Sarah on other forums, and she's also a very good speaker. So we are in for an entertainment. So for each speaker, you will have about 15 minutes in the first round. And then we will give you around 10 minutes, Sarah. Is that acceptable to all of us? And my role will be that of the timekeeper. So, either I will wave at you once you're past 12 minutes, or if you're past 14 minutes, I will gently try to come in and remind you that the time's up. So we will start with Nayana. Over to you, Nayana.
Thank you very much. I'm really honored to be part of this conversation today. Um, may I introduce my organization a little bit? I am Executive Director of Asylum Access Thailand, and we work with the urban refugee populations in Bangkok mostly. We provide legal assistance to the refugees through their connection with the UNHCR through the refugee status determination process. So work with them as their legal representation. We also work with the community members of the refugees who would like to learn about the law in Thailand and work with us to help the others to bridge the gaps between the communities and the lawyers. So they are linking us by being paralegals team of AAT. And we also doing advocacy work with the government, aiming to try to change policy and law so that refugees can have access to basic rights while they are in Thailand. So the refugees in Thailand, according to UNHCR number, we have about 97,000 refugees in the 9 camps along the Thai-Myanmar border. Most of those are the one from currently from Myanmar. But that's different from the population in Bangkok who come from all over the world. We have about 70 nationalities that fled from their home country to be in Bangkok so that they can apply for refugee status with the UNHCR and hope for a better future when they can resettle in the third country. We have people from neighbor country like Vietnam, Laos, Cambodia, but also from Africa, from South Asia, and from the Middle East. And they live in different communities, mingle with Thai communities. But the situation is that they don't have any legal status. I think similar to many countries in Southeast Asia and South Asia. So they are at risk of being arrested and detained and even deported all the time. So they live in hiding, they live in uncertainty, and what they want is to be survive and be able to looking after their family while they are here. Um, Apart from this group, there are also a few of the other nationalities that are not considered as refugee by the Thai government, and the government has prevented UNHCR from providing refugee status to this group. For example, the Rohingya, the Uyghur, or the Hmong from Lao country. So the situation for them is the Rohingya has been considered as trafficked persons, so they will be assisted by the government and placed in the government shelter for the traffic victims. But once they are there, there is quite no real plan, like what will happen to them. We learned that UNHCR has been working quietly with the government trying to give these people resettlement scheme, and they has been successful for some of the Rohingya in the government shelter, but this has to be done like really quietly because the government doesn't want to have this as a pull factor for more people to come to Thailand. But having said that, there are also some hope because there are some progress in Thailand. Since 2016, the Prime Minister Prayut Chan-o-cha of Thailand has attended the Refugee Summit in the States, and he has pledged that Thailand will develop an effective screening mechanism to distinguish who are refugees and who are the economic migrants, and also to strengthen the implementation of the principle of non-refoulement. The other pledge he has committed to is that there will be no children in the immigration detention. And we have seen that those pledges have been materialized. Last year, the government have signed an MOU among 7 government agencies to agree on working together to release children from the detention. And they cooperate with NGOs so that we can help finding place for the children and the mother to stay, providing case management for them, and ensure that they are safe and the mother has been provided for. Because through this alternative to detention for children and mother, the father is not allowed to be released. So the mother is quite struggled because there is no means of living for them. So they rely heavily on NGOs and UNHCR. And in December last year, the government have released a new regulation, which is the kind of the lowest ranking in the law in Thailand. They call it the Prime Minister Regulation, which working as a screening mechanism for refugees. So that has been released in December and being effective in June this year. But because of the COVID-19 situation, nothing has been slowed down, and we haven't seen that they have been functioning yet. But anyway, these two progress has given us hope, and we have something to work for, and trying to support the government so that they can do their commitment and their job properly in order to give more rights to the refugee. Having the the national screening mechanism, we are able to analyze the contents of the law, and we see that the advantage of it is that this is the first time that we will have a law that's specifically talking about refugees. Even though in Thailand they will not use the word refugees, they will use the term protected person instead. But these refugee, if they are going through the screening mechanism and gain the status, they will be able to be in Thailand temporarily, and will not be, well, hopefully will not be detained. We haven't seen yet what will be the management on this. If they get the status, where will they live? Can they live in the communities, or will the government provide some shelters for them? And what is mentioned in the law is that they will have access to education and to health care. again, we need to still wait and see what will be the process and the real action for them. How can they access to those services? But this also gives us a lot of concern as well, because we have seen examples in other countries where the government have started to do the screening themselves and turn the screening mechanism into their tools to screen people out rather than accept them as refugees in the country. And we have, after the analysis of the contents of the law, we have noticed that the definition of protected person is not in line with refugees in the Refugee Convention. So there are some concern there, and there is no principle of non-refoulement that will be clearly stated there, because the government still mentioned that the national security will come first, so that will overrule everything. If they consider anybody as a threat to the security of the country, that person can be deported immediately. And they have set up now already the screening committees who will make a decision on each person whether to be protected or not. And their decision would be final. There is no appeal allowed after their decision has been made. The only appeal that can be done is at the very beginning when refugees register with the government, and if they are denied the registration at the beginning, then they can appeal within 15 days, which is a very short period of time. And we think that what is very important for the refugees, if they get the status, is that they should be allowed to work. Because from our experience, whether they get refugee status with UNHCR or not, they still have to be stuck here, like living here for a long time. Even with refugee status with UNHCR, it still takes many years before they can be resettled. And resettle opportunity is getting less and less. Now is less than 1% that people can be resettled. So everybody gonna be kind of living in Thailand for a long time. Those who are here already are here for more than 5 years. So we think that for them to be able to be self-reliant and taking care of their family, their children, they need to be allowed to work. And that is the work that Asylum Access Thailand are doing together with our colleagues in the other NGOs. We have formed Coalition for the Rights of Refugee and Stateless Persons since 2015 to advocate for the refugee together. And another concern for us is that in the law, it haven't mentioned that the refugee would be allowed legal representation. And that is really worrying because of the language barrier and because of the law is already difficult for like normal people. They wouldn't understand what does it say in the law, what do they have to do. So legal representation would be an important role that we need to advocate for, that every refugee should have legal representation. We also concerned about the confidentiality issue, because we are not sure if the government will, because from what we have seen, sometimes government can share information with the neighbor country if the person is somebody that may be involved in politics, being activists in the neighbor country, and they are wanted. So sometimes there is an agreement between the two countries to share the information. So that is our high concern. And lastly, we also feel that the national screening mechanism should be inclusive. So it shouldn't be only for urban refugee as it seems to be now. We feel that the refugees who are in the camps or those from those who are in the Rohingya group or the Uyghur group should be allowed to register and apply for protected person status as well. Um, so we are working hard to advocate for this, and we do it through many channels. For example, we organize, like it at the local level, we organize diplomatic briefings so we can share the information with diplomatic missions in Thailand and uh, request them to help us advocate with the government because they have more chance to have direct contact with high ranking people in the government. And also we have produced for the global level, for example, the third shadow report or UPR process to share the report about the situation of the refugees in Thailand and ask for the global community to help advocate together so that Thailand will allow refugees to have access to human rights. And I think this platform here is also one of the good advocacy platform that we can share what is happening in our country, and with similar objectives, we can also advocate together maybe at the global refugee forum or at the GCM forum. So that's it that I would like to share at the first round. Thank you.
Thank you so much, Naina. It was
I hope
very informative.
I'm keeping the time.
Yes, you were perfectly within the time. So no worries at all. And thank you so much, because we get to hear a lot about Thailand, but not so much about what Thailand does in terms of refugees. Whatever we hear, as you've already said, that they don't have mechanisms where they can access lawyers, etc. And yes, the language is always a barrier. So, some things always stay the same. So now we will request Malini Ramaro, who is the director of DHRRA Malaysia, a Malaysian NGO, which has been working um, which has been working to address statelessness in Malaysia since 2007. They have already done a project with UNHCR from 2014 to 2016, which mapped and supported affected populations in peninsular Malaysia to acquire or confirm Malaysian citizenship. Malini is responsible for overseeing the development and implementation of her organization and strategic planning for stateless implementation. Her roles with SNAP and DHRRA Malaysia rely on her widely acknowledged ability to build and strengthen relationships with a range of stakeholders. So Malini can probably also give us a little bit of advice of how refugee groups can lobby for themselves, especially in this situation of pandemic. So over to you, Malini Ramallo.
Thank you, thank you. Yeah, so I have a screen shared. It's the slides, and I'm trying to keep more pictures in this. So for the purpose of this discussion, this session, I would be very much focused on evidence-based advocacy, how we collected evidence, and then moving on, how did we use that for advocacy purposes. So just a little background about statelessness in Malaysia. Statelessness is a person who do not have any sort of citizenship of where they can claim from any part of the world. And the persons who are stateless in West Malaysia, that first time we came across was back in 2003 when we were working on a project in the plantation that was meant for Indian communities. So we would teach them skills of income generation, and then they were in the rural areas, so we were trying to help them with the transition. And then we realized many of them had a different identity card than ours, and they would probably have a red color identity card, and it meant that it was a permanent resident, and many of the children were undocumented or did not register their birth. And so we were really focused at trying to assist this particular communities that showed potential in terms of like developing their own businesses. And then that's when we came across that these people would not qualify for government assistance or any subsidiaries that we were trying to kind of reach the community with. So that was really the start of how we came across statelessness. And at that point, we didn't even know what the term statelessness was. So it was a journey, really. We started visiting the National Registration Department to understand the process. And then, we were relentlessly going back and forth trying to fix particular individual's document. Then between 2011 to 2013, somehow the issue started catching a lot of political attention, and there were political parties that would cite that, oh, we have about 400,000 Malaysian Indians who are undocumented and they have been left behind, and what do we do with them, etc. And that's also the time that we continuously started seeking assistance from UN agencies or any agencies that knew what the problem was, because the Indians that came from India to Malaysia, they were not refugees. They were laborers that were brought in pre-independence back in the days of 1950s, So, and there was there was a method of accusation for citizenship, and they were given the opportunity to do so, and we wanted to know why they were fallen out of that, that particular provision. So we definitely realized that it was really important for us to do mapping and getting an accurate baseline data. That also came because like every cases that we went to try to assist, they didn't seem to have trust because they had previously reached out to political parties or community leaders who didn't seem to be able to solve their solution, their situation, or even to begin with, some of them were cheated, where they were asked to pay a certain amount of money and they didn't have a outcome from it. So between 2014 to 2018, we eventually got into this huge project, really invested on with huge amount of funding as well, where we had a provision of paralegal, and we wanted to identify, which means map, as well as register stateless people in the National Registration Department, and obviously after that to identify the causes of statelessness and what really was an issue within the community. And so of course, in that period, during the implementation period, it was a very well thought project because we wanted to reach out to the community. So we had community-based paralegal, and then we had database, both physical as well as an online database. And the database was very important for us because we were able to find the patterns of discrimination. And then eventually in 2018, we were able to come up with recommendation, and also successfully, probably around this year, well, from last year, June, we were able to implement and get the government to take some action. So that's probably the journey that we had. So I'm just going to go into the community-based paralegal. Before I speak too much on it, there is a book that is available that DRA has contributed with a few other countries as well. It actually speaks about the advantages, disadvantages of having a paralegal, community-based paralegal in your project when it comes to documenting citizenship and other forms of legal identity. So it speaks about funding, it speaks about how do you handle relationship with stakeholders, as well as many other areas of your work eventually in that project. So I'm sure many here has already known that, paralegal, they serve as a link between the community and the government. So the beneficiary can overcome the language barrier and literacy, and it promotes stronger beneficiary acceptance of the legal assistance. And most importantly, you can reach out with trust, accompanying a community in navigating administrative and judicial process. What was really important for us was that the person who was going to be trained as a paralegal had to be from the community. And I'm speaking about the stateless community that mostly do not stay in one area. So sometimes refugee, you would find them in
concentrated areas, whereas stateless communities in West Malaysia is none such that. Instead, they are very dispersed. So it was very important for us to sort of map that particular area and have really wide areas that we were covering with kilometers long, where the community member had to know a lot of things. So this community person, community-based paralegal, was helping us with the mapping exercise. We obviously had two types of mapping exercise, which is door-to-door visitation and then collecting the information, as well as conducting, a mass kind of, mapping session where we would do it in the halls and, public areas. So the case management database system that we had in place was something that was very, we really invested our time and thoughts into this. So we have a central database, which is an online platform. And then we had Android, as well as physical registration. So the physical registration was to collect information just in case, anything we lose on the online form. But the mobile Android system would help me to get a picture of that stateless person. So that's to avoid any duplication, any spelling errors. So, we had a system that was put together just so we could double check on the content that we were receiving. And of course, community-based paralegal who kind of linked up all this together and then brought these cases to the National Registration Department. So this is how the Android looks, our app. It's a collection of information, what type of application, whether it's birth registration, identity card, or citizenship, kind of race, gender, and which particular area you come from. And of course, we could put in the file number and take picture of the person, and then we could save the record in. This is the database that we have. So this particular database has very, very detailed information in terms of the background of the cases, whether they were foundling, whether there was an illegitimate marriage that took place that caused statelessness. It just identifies different root causes that could be involved. So this is the I would say the dashboard that we're able to collect the data in the sense that what's the statistics, what's the breakdown by states, and how many are, how long does it take to process a particular case, and just different range of information. And I would say this was really the strength of our project, because it was through this database we were able to identify patterns of discrimination and how they were related to different type of applications, and how different articles were used to sort of delay the whole process of application. So here we are, the number of cases we were able to identify, and this is really not an updated figure, but today we have almost more than 3,000 or 4,000 successful cases who have already become Malaysia. And of course, the number of stateless cases has increased eventually because we sort of broadened up from the Indian community. We moved out to include every other communities in the country. Litigation was definitely part of our project, and stakeholder engagement, because we had to communicate with them. And our strategy has been very, very gentle. It wasn't confrontational. So I would say, despite having the information, the data, and the evidence, we would go and meet them in person, and we will tell them that we're finding this particular pattern, and can you help us, and what's wrong, and what could be causing this. So we had very, very fruitful discussion, even with the National Registration Department. And of course, this information are very sensitive that, throughout the years, we were very careful about how this information was communicated or even published anywhere. So that really helped us with building good relationship with the National Registration Department and several other related agencies. And one big other success that we received was, for the first time ever, that issue was covered in a national blueprint. So the statistics was based on DRA. It wasn't a Malaysian government statistics. It was rather something that they had picked up from DRA. And these are some of the exercises that the government had requested us to conduct from there for the Prime Minister's office, and we also conducted a national mapping process in West Malaysia, which was completely funded by them, headed by them, but we were the technical person who were assisting them with the mobilize the whole thing. And so this is a policy recommendation we drafted, and we started meeting people in the parliament. These are the MPs. We would share to them, and then we realized that the recommendation paper document that we were sharing was not interesting enough. It's just too much of information. They couldn't understand. They didn't have time to go through it. So we came up with an infographic handbook that would sort of like directly point them that, look, this is the statistics. This is where exactly the problem is. And it's very short. Like we had that little book would cover a lot of things. And so it was direct, straight to the point that really helped us to put the message across. And then of course, meeting NHRIs, you know, UN agencies. So one big success, major success that DRA had was back in 2003, we didn't know what statelessness was. When we're trying to convince the government there were statelessness, they said there is no such term. And today, which was last year, we had the Home Minister, who is now currently the Prime Minister now, but the Home Minister went to Geneva, attended a program with me on the high-level segment on statelessness, and actually spoke and said that they are in the process of addressing statelessness. So some of the successes that you could see that is based on the database that we have, 3,000 over Indian residents will gain Malaysian citizenship. This happened last year. And then sometime between mid last year till now, the government has said they are reducing statelessness, they are working on the SOP, they are changing the SOPs based on the recommendation that we have provided. So this is the strength of evidence-based advocacy. And so I'm almost on the last slide now. So I wanted to share really on the sustainability factor. So we had a strategy, we wanted to find data evidence, we did. We wanted to reach out to the community. We wanted to know how can we help them and also document this evidence as per our advocacy so we could change things. But then we realized that one of the biggest strengths, as I mentioned, community-based paralegal, they, even though we stopped paying them, they continue to contribute for the community. And today I still have all the 60 community-based paralegal that have trained over the years. My organization has trained, and they continue to sort of like amplify the work that we do. They are ever available. They can go to the national registration anytime. And we never had to worry about them coming back to us saying that no one has the information or how to do about it. And it's something that we never knew that could be very impactful. But yes, today's stateless communities have been able to speak from themselves. And that's one of the greatest achievements that we had. Because from the earlier times, they were not willing to come and speak up because they didn't know where they belong. They didn't know they were not from somewhere else, but you know, they had no explanation of how they were just stateless. So today we have achieved really so much, but I think apart from evidence-based advocacy, when you lead and leave it to the community to speak for themselves, we can really achieve a lot of things. That's where I'm going to end. Thank you.
Thank you so much, Malini. You have given us some rays of hope, which is fantastic. You've talked about some achievements of the stateless community for the stateless community. Now we will move to Rizka Argadianti, who is a human rights activist from Indonesia. She was born in Papua, and her birth is around the issue of freedom of religion and belief. As I had earlier said, she had worked on the human rights violations against the Ahmadiyya community, and very recently they published a report called Barely Living, which is on the Rohingya refugees in Indonesia. So, Rizka, may I request you to speak?
Thank you, Paula. So thank you very much for today and the opportunity given to Suaka to speak today in this conference. And I'm very much proud to be in a panel with all amazing women in here and also you, Paula, as the moderator. Thank you very much. I'm Riska. I'm currently the chairperson of Suaka. Suaka is an organization which providing legal aid for refugee and asylum seeker. And our work is not only to provide legal aid within the UNHCR process, within the RSD process, but also within the police or immigration process. And not only that, Suaka also works to do the advocacy for policy changes and also campaign for public awareness within the Indonesian society and also legal empowerment for the refugee community so they know what legal process applied in Indonesia. So I'm going to start because I was requested to speak about the presidential decree, the PRESTEC, which I can short it as the PRESTEC. In 2015, Indonesia received more than around 1800 Rohingya refugees. And after that, a year after that, on the last day of 2016, the President Joko Widodo has signed the PRESTEC number 125 on 2016 about the handling foreign refugees. So it's actually we doesn't have any same language between the refugee and pengungsi in bahasa Indonesia. But then if we put 2016 as the starting point, but before that we have 2015 about the Rohingyas coming, and after the presidential decree was signed, enacted officially in 2020, uh, we have also the another wave of Rohingya refugees in recently. Um, we did the discussion last week actually with the local government, with the central government as well. We invite the Office of Presidential Staff and also the coordinating Ministry for Politics, Law and Human Rights to speak on behalf of the central government. And we invite the local task force in Lok Sumawe in Aceh. We invite them, but unfortunately they cannot come in actually. And also the CSO in Aceh. Uh, on that discussion, there are certain things that popped up. We actually didn't really aware of that they have the central government have a concern on this issue because previously we always hear that for them refugee is a national threat. The point of view that they use when they draft a regulation is that the refugee, the foreign people coming into the territory, is the national threat, and they have to establish the security system to protect domestic people or the territory, which is actually normal in each country, but this is too much for refugees. If the refugee coming, they could be in a detention center, but after the presidential decree enacted in 2016, there's an article stated that refugee can be put outside of detention center. And in 2018, the immigration office issued the internal letter. It's kind of a circulation letter only circulate within the immigration office, which stated that the IDC, Immigration Detention Center, is not for refugee based on the purpose. And currently, there is only 6% in IDC, one woman, non-children, and they are waiting to be placed in a shelter. Or some of them then violate the immigration law. So The IDC currently in Indonesia is actually only for those who violate the immigration law, such as um, they violating immigration law like overstaying, or they make a fake passport, they make fake travel document. Once they declared they want to have they want to be registered in UNHCR and they are registered in UNHCR, they can be put in outside of detention, they can be sheltered. And yeah, back to the discussion last week, we found out that the government actually stated that this presidential decree is not sufficient, which actually civil society organization also stated that this presidential decree is not sufficient. This is the only regulation that Indonesia have on handling refugees issue. If we read the presidential decree, it's always about the procedure. If we found, this is what the press say, if we found refugee on a boat or in the airport, what we should do, what the civil society should do when they found it, what immigration should do when they found it, what police can do if they found it. And then after they found it, they were going to secure them in a place that they need to be secured. And then after it, they need to be in a place, in a shelter, or in a place that immigration have an authority to do that. And then how to establish the security system, how to supervise them. So it's kind of procedural, A after then B, C, and D. But there's no right-based approach. Like children can go to school. Children has a right. Refugee children has a right to school. So in this discussion, we finally knew that the central government also have this concern. Um, and this regulation also seems not confident because of in the last article in this press said that the national budget can be used to handle refugees and asylum seekers, but up until now from 2016 there is no budget allocated for this matter in Indonesia. And the local government in Aceh or in every cities in Indonesia asking for the central government about this funding because they don't want to use another allocated fund to do it in another activities. Otherwise, they can be put in jail because of the corruption or misallocating budget. And this is what also central government aware, which I kind of surprised because they are aware that they are not really put funding allocation for the local government. So even though there are circulation letter to implement other thing also, the regulation is still not sufficient. They are aware of that, and they are aware that as the central government is the role is to provide the regulation. This is what they're going to do, and this is what they ask for CSO, for the civil society, to give them insights on what kind of regulation that they will do. This is kind of actually a long campaign done by civil society in Indonesia, including Suaka, that since 2011 this presidential decree was drafted. At least on 2011, Suaka was invited for the national roundtable, national consultation for the draft, and we give inputs in each articles. And then it comes, the press deck comes with actually a good starting point. Then we finally realized that this presidential decree is not sufficient. And after that, the central government has aware of that. And yeah, for currently, for now on, Swaka will also hand in hand with the central government to kind of drafting regulation or having consultation with the local government as well on how to allocate funding. on how to handle refugees in their area. Though immigration are still reluctant, and also manpower ministry are still reluctant for this issue because of Ministry of Manpower this is related to the life sufficiency of refugees, and they don't want to issue permission for the foreigner to work freely without any permission, without any documents that already in a law. So there's still resistance from the certain ministries, including immigration. So yeah, the last words from me. If having a law is a utopia for us, means presidential decree is lower, way much lower than the law. So we are going to approach the highest authority then to enact the regulation. Presidential decree is sufficient. Maybe we can have another presidential regulation, but based on the right-based approach. And to empower refugees with legal knowledge, which actually, because they are the beneficiaries, they should know what legal terms, what law applied in Indonesia, and what rights they are guaranteed by the regulation. Actually, today is the first day of our second batch paralegal training, community-based paralegal training. So last year was our first batch, and today is the starting day of the second batch. And we hope that with the training, which is the only one actually in Indonesia for a paralegal training, community-based, refugee community-based paralegal training. We hope that they can spread the words, they can spread the knowledge within the community, and the community can be empowered legally. Means they know what they should react accordingly if something happens, because of, you all know resettlement rate is already low, and the opportunity to stay is way longer, and and if they interact with Indonesian or even within their own community, it could be have a friction or conflict. So yeah, that's the last words from me. Thank you.
Thank you so much, Rizka. Now, I will request Sarah Hussain to make her comments. Sarah Hussain is a barrister practicing in the Supreme Court of Bangladesh, mainly in the areas of constitutional, public interest, and family law. She is a partner at the law firm of Dr. Kamal Hussain and Associates, and currently serves pro bono as the Honorary Executive Director of Bangladesh Legal Aid and Services Trust. She earlier ran the South Asian program at Interrights from 1997 to 2003 and was a founding board member of the South Asian Women's Fund. Sarah's most public interest litigation, most significant ones, have to do with women's rights. We have all heard of Sarah regarding her litigation on fatwa, as well as on the question of forced whaling
Thank you.
regarding the rights of women. So over to you, Sarah, for your comments.
Thanks so much, Paula. So it was a very interesting panel, and I learned a lot. I mean, I think that some of the things that I feel very unqualified to speak on Southeast Asia. So I'm just going to, I think, comment a little bit based on what I learned and what I think is very useful for us to understand from our perspectives in South Asia, but maybe also just to draw out some of the common themes. I think one point that's significant for all of us is, of course, that none of us are refugee convention ratifying countries. So we are looking primarily at our national systems and how our national systems can be effective and responsive. Another reason, another gap, I guess, which pushes us in this direction is we don't really have a regional human rights mechanism for the whole of the Asia Pacific. Now, I'd like to hear a bit from the speakers about how much they find the ASEAN processes and mechanisms of use in their advocacy work as well, because in South Asia, of course, we have a less functional process in the SAARC process, and it's not really one which we, I think in general, tend to find particularly effective. And again, this pushes us back into the national space. Another, I think, contrast maybe, rather than a comparison, is of course the countries we've just heard from. Thailand and Indonesia have civil law systems, and for Bangladesh and Malaysia, and indeed India and Pakistan and in South Asia as well, we have common law systems. And again, I wonder if that makes a difference in terms of what kinds of strategies and approaches we can take. So in our systems, public interest or strategic litigation or judicial review, all of these are different names of the same thing in a sense, but those are available. I don't know exactly how effective those are in civil law systems and if they're used. But going back to, so looking in focus in terms of the kinds of problems people have been talking about, clearly the lack of secure legal status has been the primary one, but issues around discrimination in terms of, as a consequence partly, in terms of access to services and protection, in terms of basic rights, in terms of security or liberty or expression, all of those issues I think that have been flagged up. And also vulnerability, whether it's to trafficking or forced labor or other forms of exploitation. I think what I heard from all the three speakers was about how they've utilized national legal frameworks and how each of them are pushing on trying to adapt the framework, amend and change it where necessary, not only to be compliant with the kind of protected rights under the Refugee Convention, but also to be practically accessible. And that means advocacy at many, they've been doing advocacy at many different levels, as we do in South Asia, I think, as well. But they've also talked about how, not only how they're working on recognizing rights, but also how to realize them in practice. And that means, again, with working at the international level in terms of the recognition and support for realization, at the national level with government, with state agencies and so on, with also independent bodies like the national human rights mechanisms. And very importantly, I think I heard all the speakers talk about how they're making this critical connection between what's happening at the international and national level with the community, with the ground, and within civil society as well. So from that perspective, maybe if I just take a couple of minutes to maybe give some perspectives from where I sit in Bangladesh, and you know, as a lawyer, but working with an organization that is also involved in very similar activities. I think firstly, we also see positive practices and developments at the national level. Of course, let me talk about the legal first. I was going to say, obviously, the hosting of the Rohingya community, in a sense, is the biggest, most visible, most significant recent development. And you know, kudos and so on to the Bangladesh government for continuing with that, with sort of still continuing international support, but obviously the bulk of the role being taken by the Bangladesh government. But in terms of legal changes, we have some important recognitions. We have legislation that recognizes universal birth registration. We have some important Supreme Court judgments. For example, a judgment that recognizes the right of citizenship of a community, not in relation to the Rohingyas, in relation to the so-called Bihari community or Urdu-speaking community, a community that had migrated into what was then Pakistan after the 1947 partition, what became after liberation Bangladesh in 1971. But that community had leaders of that community had very contested relationship in terms of recognition of Bangladesh and recognition of our independence. But despite all of that, the law recognized that those born on these territories and who had predecessors born on these territories had a right to citizenship effectively. And so the High Court's recognition of that and the way in which that entire public interest litigation happened gives us some indication that, you know, very fundamentally believed notions about exclusion and about who belongs and who doesn't belong can be changed. As I think a Malaysian speaker was saying, through systematic evidence gathering about people's experience and through detailed analysis of the law. We also have an interesting recent judgment from the High Court about recognizing the principle of non-refoulement as a tenet, as a basic principle of customary international law, and applied in the context of Rohingya individuals who were being held in prisons, who were then returned to the camps, who were directed to be placed in the camps as part of the recognition of that. And we have recently recognition, a government level, high level recognition, government level recognition that Rohingya children will be able to receive a formal education. But exactly as all the other speakers indicated, there's often a gulf between the recognition and the realization in practice. So much remains to be done on that. And there are some, there are significant challenges. And that's why we at BLAST, along with other organizations in Bangladesh, continue to work at a ground level in the camps and outside with Rohingya communities, who are the largest refugee community in the Bangladesh context, as well as with Bangladeshi communities, to try and sort of build common understandings, to break down, I think, resentments and hostilities, and also, exactly as speakers said, to provide community-based responses, working with community volunteers from the Rohingya community, as well as local persons in the area, to provide paralegal services, and also pro bono legal services from the Bar Association through BLAST. And I think some of our learning from that is we see, and some of the work that has been done with organizations such as Open Society Foundation, Refugee Solidarity Network, has been very important to understand, since we're talking about national contexts and national systems and national laws, what laws actually apply and what laws potentially apply. So in the context of the camps, there's often an implicit assumption, or many times explicit also, that certain laws just don't apply to Rohingya and everything is different inside the camp and there's a whole different world inside the camp. But actually, that's not so. The laws in Bangladesh, the camps are within Bangladesh territory, and there is no order saying the camps are excluded from application from Bangladesh law. So of course, Bangladesh laws do apply. And we see that they are applied in the case of, for example, serious cases of gender-based violence or serious crimes. In many respects, Bangladesh laws are applied, Bangladesh police get involved, Bangladesh courts are involved. Some cases they don't apply where they should, even in those serious cases, and those have also been documented by human rights organizations about cases of alleged extrajudicial killings, for example, or some cases of GBV which don't reach the system. But we also see in other cases that should reach the system don't. So for example, we have a state legal aid program, which is very effective in many areas, run under the Bangladesh judiciary and with the law ministry involved with that. To date, the legal aid system has not taken in cases from Rohingya refugees, but there is no actual barrier and the legislation prevents that. So these are the kinds of issues on which we are doing advocacy to see what's possible. And I think that detailed analysis of the legislation and looking at where it includes citizenship as a criteria and where it doesn't is a very useful way to approach the process. So then in the areas that we know are significant, in the area of family disputes, for example, in the area of GBV, in the area of trafficking, missing persons, detention, many of these are the issues that come up often, which we need to relate to. So I just want to wrap up just by going back to what the speakers were saying and sort of go back from our consideration of Bangladesh. I think what I found very useful in terms of Nayana's presentation was, of course, talking about how this MOU, the partnership approach between government and CSOs in terms of affecting release of detained children, and also not only enabling the release, but then seeing how to do all of the steps that are needed after that. Where do you get shelter? How do you find people? And utilizing the CSOs, obviously extensive and well-established networks to do that. I think what was also very interesting from Nayana was talking about the extent and the limitations of recognition of the international rights. So Nayana talked about how the definition of protected person is different from what is recognized in the convention, and also about this preeminence given to national security. That's something we see, I think, in many of our systems, that becomes the ultimate block. But of course, national security can be interpreted in very wide, expansive, and problematic ways that don't really apply. And so there's a question about how much is it possible to involve the judiciary in questioning this process? Are courts robust enough to deal with that? How do you bring attention to the fact that national security can also be questioned when it's applied, and it shouldn't just be act as a blanket ban. I think the other question I got from the other issue I think was raised very strongly by Nayana was around confidentiality and privacy, and also around the risks I think that she raised in terms of, which I think were reiterated by the next speaker, around, having information. How is that information used, and who is that accessible to, and how are we sufficiently aware of the risks involved there, and are we protected against that? So not only in terms of surveillance, but in the use of databases, what happens when those databases fall into the wrong hands? Who is able to access those? What kinds of security is there against the abuse of those systems? And I think all three speakers, Malini and Rizka and Nayana, spoke about the importance of the community and about drawing from the community and ensuring support to the community is one aspect, that providing technical support, but not just technical in terms of legal knowledge, but also the networks and the very strong resources that all of the civil society organizations have, that they can access and they can utilize to support the community. That's crucial. But at the same time, strengthening the community, engaging the community, and having this interface, having the paralegals. And four things I heard were trust, knowledge, and links, the connections. These are the three things that paralegals can bring to a process. They can build trust in the community, who feel then able to access formal systems or informal systems which they may otherwise be wary of, giving knowledge, giving capacities, and connections. And just, I think, maybe the final 2 points I'd like to make is, again, just going back to that warning perhaps around that maybe we're not sufficiently cognizant when we're using databases which are immensely useful. And again, what Malini talked about was, fascinating how they set up this database with incredible kinds of information around all of the different aspects that need to be looked at. But I think the security of databases, the security of private information is something we need to be perhaps more aware of, and we don't have often enough sense that this is a risk or enough idea about how to tackle that particularly. And I think the very final point is about how do we do the advocacy. I think what we're doing today is a very important part of it. All of the speakers have talked about the advocacy at the national level, government stakeholders actually at both national and local level. Rizka also talked about all of the work in Archie. So remembering that stakeholders and their engagement at national and local is very important, not just going right to the top or not just staying right at the bottom level. The international advocacy everyone's talked about, using the Global Compact, using the Global Refugee Forum. I'd like to just finish with asking the question to the speakers, I think, about what about the regional spaces? Do you think there are regional spaces you can use? All of you in the ASEAN context, is that something that you can utilize? And this kind of process, I mean, reaching out across South and Southeast Asia, I think is a very, very valuable thing to do. I can see, incredible lessons for us, as I've just said, from all of your work. And I think that although we often, have our backs to the wall and not much time to do much beyond what we're already doing, I think facilitating these kinds of very specific conversations is immensely useful. And I'd really, I think it would be wonderful if Calcutta Research Group is an obvious resource for all of us across the region on these issues. If you could think about facilitating sort of more micro conversations as well on some of the issues that have been highlighted here, whether it's children in detention, whether it's, we didn't hear so much, I think, here about family issues. I'd also like to put that question to all of the speakers, but is that an issue you deal with in terms of family conflict, not just GBV, and how do you respond to that? So let me just end there, Paula, thanking you and the speakers again for just a fascinating session.
Thank you so much, Sarah. And I'm so glad that you were the discussant, because you really brought out a lot of points, which we were all, I'm sure, thinking about, points about communities, point about the law, which is your special expertise as to where, often we assume certain things work at certain places. But, for refugees and migrants, assumption is not enough. We have to really go through the text of the law. And it would be very remiss of me if at this point I don't invite Colin Schufer from the Open Society Foundation to perhaps say a few words. She created this panel, she made it possible for us to hold this conversation. And I hope we will be able, as Sarah very rightly suggested, take up, point by point at micro levels, issues which are so important. And also, we haven't touched upon too much internal displacement and the rights of, IDPs within the context, because, there is one thing is having de jure rights, and there is another thing is having de facto rights in our particular region. And often IDPs and protracted IDP situations, as we see in places like Philippines, they're often treated as, um, almost the refugees, as rightless as the refugees. So, I will reserve my comments, but Colleen, do you want to come in now and say a few things?
Hi, good morning from London. It's very early here. But I just
Oh
wanted to
God.
say thank you so much for all the speakers for your really interesting explanations or elaborations. It was really fascinating to hear how different organizations at the national level really use creative tools to advance protections for migrants and refugees. And it's really inspiring to hear everything that's happening. From what we're doing as like the Open Society Justice Initiative, we're obviously an international organization and we work closely with other international organizations, but also national organizations who really understand the context in a way that we don't. So what we try to kind of, bring in, but obviously listening to people who are so much closer to ground, is comparative insights and the value of those. And what we've really seen across not just South and Southeast Asia, but also really across other regions, is that there's so many positive practices and there's so many, but these aren't extended like universally to everyone, and that's the problem. So as like Nayana was explaining in her presentation earlier, and other speakers spoke to that too, is how different groups, whether that's in the criminal justice system or whether that's about access to family courts, receive different treatment, different protections, often based on characteristics that they shouldn't be discriminated against based on their religion, their nationality, gender. And I think it's really interesting to hear like the different ways that, as Malini explained about evidence-based strategy, the different ways in which local organizations, like national organizations, have really been creative and displaying these patterns and using various tools to advance them. And I was wondering if speakers or anyone here could really speak to, because as we're exploring all these patterns of discrimination, a big question that keeps arising is how do you lay these bare, and what strategies can be used to kind of demonstrate that, and add fuel to the argument that protections should be applied inclusively and across the board. So if there's any, other strategies that people have in mind, or other situations where, this was something that needed to be proved, it'd be really great to hear more about. Thank you again, everyone, for such an interesting discussion.
Thank you, Colleen, for putting in so much work. We really appreciate what you've done, and thanks to Open Society Foundation as well. Now I will go through some of the questions that were sent to me by the participants who are listening to this wonderful conversation that has been happening. There is one question. I'm not going to name the people who asked these questions, but there's one question on the Tamils, the particularly the Tamil plantation workers in Malaysia, Malini, and what their status is. There's another question about people in the detention camps, if there are detention camps, and what about the people there, and how do they access, law or legal rights to be represented. There was another question about, data collection to Nayana about, how is your organization accessing the way Malini's organization is in terms of data collection and building a big data sort of a network. And based on that, what are their activism? Then there is a question on, how do these organizations access, particularly Malini, how does stateless people access your organization? And, and I think the whole notion of statelessness and citizenship is something which is becoming very, very important in the context of South and Southeast Asia. I mean, look at the situation of India and NRC. And we have this, potential for making hundreds and thousands of people stateless as a result of these NRC determinations and the new, citizenship laws, etc. So I think, as Sarah was saying, these networkings between South and Southeast Asia is now crucial. And there's a lot of question about women refugees and migrants, whether, how far are they able to access rights and entitlements that are there for them. And I also see a question on how much has the pandemic eroded the situation for refugees and migrants in these different countries. And as Colleen was saying, maybe if you want to reflect on what can be done at micro levels, I mean, we all know what can be done at the macro level with the state system. But here I'm talking about the people to people initiatives where we can all come in and create a network of like-minded people and, and see what we can do from there and take on the some of the activities that have been suggested in this discussion. So I will give the speakers maybe 4 minutes each um, for your reply, because we are nearing the end of our session, and I know a lot of young people out there in the hotel in Shonargaon waiting to go and grab their lunch before the next sessions. So I will start with Diana, and then Malini, and then Rizka for on any comments that you want to make.
Okay, thank you very much. So I would like to thank you. I think all speakers have shared very interesting information, and I see that some common ground that we are doing is the community-based paralegal that can become people who can join and talk more about themselves and advocate for themselves. Um, in Thailand, we are working now on what we call refugee-led advocacy, that we are preparing the refugees so that they be able to advocate for themselves once they get the legal status, because at the moment it's still too risky for them to do so. On the question about data collection, in Thailand, we have our internal database for the clients that our lawyer do legal represented for them with the UNHCR at the moment. And we hope that we can do the same once it turns to be the government state refugee determination status. But we do not share the database with others. So I guess we need to figure out once it becomes the state mechanism, what can be done in terms of keeping those data secure, and what do we do if the government asks that we need to share the data with them. I think that's something that we need to prepare and see how can we protect those information. And thank you so much for Sarah mentioning of the ASEAN mechanism. I think that's what we really would like to push for the human rights mechanism in ASEAN, but as we all know, it doesn't really work well. Last year, Thailand has shared the ASEAN Summit, and there is the People Forum that organized by NGOs in the country and in the regions. And we try to put together our statement to say, well, what is needed in terms of human rights in the region. but we haven't get any response back from the government. We have submitted the statement and nothing uh, is in response for that. Even to organize the meeting for ASEAN People Forum, there is a lot of struggle for us last year. Um, and we were pushed to organize our event quite far out of the city. So very few people can reach us. And yeah, I think at the moment we have a lot of political situation in Thailand that make things difficult in terms of human rights. So I hope that us here can be the real the I know what to say, like we can push together to make ASEAN works better in terms of human rights. Thank you.
Thank you so much, Nayana. Malini, would you like to respond now?
Yeah, sure. So I'll start with Sarah's question on ASEAN as a regional body. I share the same comments as Nayana had spoken earlier, that it was never an easy journey to actually get them to speak on human rights. But because we have been doing this for years, what I realized is yes, ASEAN instrument is very much focused towards rural development or anything to do with economic upbringing and sharing of resources. So in the recent years, maybe in the last 3 or 4 years, the national human rights instruments have been very, very helpful to connecting to ASEAN when we speak about human rights. And then what's really, really have been advantageous for us to is form networks in the region on statelessness or refugee networks and etc. And from there, using that networks to actually approach ASEAN. And for me, yes, statelessness, it was never an easy journey to directly approach them. But because I belong to another regional network on rural development, that was a stepping stone for me, that I could actually go and speak and ask them what's their stand on statelessness, and actually put some inputs into the documents to consider having this as part of their strategies. But it's a process, it's a journey, and I think every country in the region would sort of like agree that different issues have different sensitivities and how they want to handle. Again, Malaysia and a few other ASEAN countries, we share the border. We have the mixed migratory context coming in play, and there's we're forever probably saying that's mine, that's yours, and this kind of discussion, right? Now moving on to the question on the Indian Tamils and the plantation. I'm not too sure what's the question about, but if you were to ask what's their current status in terms of documentation, yes, large number of them have already gotten their documentation, but we continue to have people who remain to be stateless, is either not having any birth proofs at all, whether they are foundling, abandoned, and now they're probably already 60 years old, and etc. And yes, the government have failed and continue to show resistance towards those kind of application, despite having a good command of the national language in Malaysia. And that particularly comes because we still have good number of Indians coming from India and then migrating and living here. And so it's really complicated. It's really NGOs that actually have put forward like what are the logical assessment that we should have on people who have come before pre-independence and then now. So if that's the perspective that you're asking for, this is where we are in terms of West Malaysia. I was shocked. I'll have to tell you this, that the only Indian community that I knew was probably in the West Malaysia, and only very recently I was invited to fly into East Malaysia to find out there was actually Indian communities that was brought post-independence in the 1963s. And they have actually now, they are in the plantations, but they don't even speak any of the Indian language anymore. They don't have any connection to what we feel connected as Indians in West Malaysia are. And they have eventually gotten married to a lot of Indonesians because of the borders that they are. And a lot of them are undocumented because of the mixed migratory context that they have. But
essentially they are the same Indians that were brought from India and then moved to a plantation that was like completely another side of the country. So we felt very responsible to them because we probably addressed the West Malaysian issues because we knew their background, and probably we couldn't do much because they were in the East Malaysia context, and we were facing with another set of proofs that we had to connect to and actually prove their existence, right? So that's a new challenge that we have in terms of the Indian community in the East Malaysia. And the question on how the stateless people access our organization, I think it's very important to know that we're speaking about a grassroots community, and we never used the term stateless. We never used anything. We used pictures to actually communicate with them. So we tell them, if you don't have a blue IC, which is the national identity card in Malaysia, reach out to us. So we went to the I would say the native language, radio channels, newspapers. We would give out flyers. We would join, local MP celebrations and then take opportunity to tell people that if you have problem, reach out to us. So it's really going local in whichever way that fits your context, just so you could have people to come to us. So that's exactly the strategy that we had. But of course, once we started getting data, once we were reaching out, writing in the newspapers more, people reached out to us and we didn't have to do much of the groundwork anymore. So that's exactly how the stateless communities reached out to us. I'm not sure if there was any other question for me. Did I miss out anything?
No, I think you pretty much, responded to most of these. So can we now request Rizka to come in? Rizka, if you have any particular comments, please.
Yes, thank you. So again, about the presidential decree, yes, it was enacted in 2016, but we've spoke to the local government in many cities in Indonesia about the Prestet, and they are not really aware how to implement this presidential decree. This is also the lack of knowledge on how to implement it, and also the lack of funding on how to implement it. And about the region process, and yes, it's actually with the wave of 2015, there is a call for a Bali process, which every government always says this is a burden sharing, but the CSO always says this is the responsibility sharing, which is felt at the time and also felt with this time also in 2020. So the it doesn't really seem having the significant impact, whether it's before on 2015 or after in 2020. So yes, there is a need for further advocacy on that. And for the during this pandemic, this is very difficult because of that the president and the local government also they have their own program on social helps. So it's like a basic needs that they can give to the Indonesian people. But unfortunately, because refugee cannot work in here, they cannot sufficient have a self-sufficiency. The support from the government is not touching their house. It's not knocking on the door. So UNHCR and also civil society organization is trying to list the refugees and asylum seeker in their vulnerability criteria list. It's succeed, but unfortunately, again, it's only on the paper. In fact, that there is no, at least from the Slovakia side, we never heard, we never get any information. If we also ask to the refugee community, we never know that there is a refugee household receive support from the government. So yes, it is on the list that they are in a vulnerability criteria to receive the helps from the government, but in the implementation is a different level. So it's about recognition and realization. In presidential decree, the first article is adopting the 1951 convention, but realization is a different level. I think that's only for me. Comment.
Thank you
Thank you.
so much to all three of to Sarah for very informative session. And of course, a huge thank you to at least three very important messages. One is about community exactly means, and when we are working in this field, as to which law is suitable or applicable to certain areas, particularly in terms of camps, which is often used as a place which is shorn of any sort of legal entitlements for the communities living in camps. And also, I think a very, very important thing that we heard today is how data collection and a pro-rights, pro-human rights way of using that data can help communities which are very disempowered way that we have in South and Southeast Asia. And of course, we all concluded that it is important that we get together because, I always feel that these alliances are very, very important because it helps us to move forward. It gives us that, encouragements, because working in these fields can often be debilitating and discouraging, particularly in this day and age of pandemic, when it seems like we are all living in islands. So I think reaching out is very, very important at this time. And Calcutta Research Group is committed to reach out and create these networks. So, as I always say, that today you're invited here to speak, but we adopt our speakers as part of our families. So we hope we can get together and do more for the communities that are really in desperate need. Thank you to all four of you and to Colleen for coming in and giving us this wonderful session. I will now say bye-bye and request you to grab some lunch. Let's hope we can all have lunch together next year right around this time in Kolkata. Thank you. Bye-bye.
Thank you.
Thank you. Bye.
Thanks and
Thank
bye.
you so much.